Call to order a regular meeting for the Normal Town Council for April 1st, 2019. Please call the roll.
Mayor Kus?
Here.
Mr. Fritzen?
Here.
Mr. McBride?
Here.
Mrs. Cummings?
Here.
Mrs. Lorenz?
Here.
Mr. Preston?
Here.
Mr. McCarthy?
Here.
We'll begin with a pledge of allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we get into the meeting, I apologize to the council. I left my hearing aids at home, and now you can't tell if I can't hear you or I'm just ignoring you. We've had no request for public comment tonight, so we'll go right to the omnibus agenda. Items that will be handled with one vote, unless a council member would like to pull an item for discussion. I would like to be excused from voting on any bills I may have incurred in my duties as mayor. Mr. Fritzen?
I'd ask to be excused from voting on the Bloomington offset bill.
Move approval.
Thank you.
Second.
Items considered under the omnibus agenda tonight are approval of the minutes of the regular council meeting of March 18th, 2019, and approval of Town of Normal expenditures for payment as of March 27th, 2019. A resolution authorizing the execution of a 3-year agreement with Gateway Fireworks Displays of St. Louis, Missouri for the annual 4th of July fireworks display. A resolution to accept bids and award a contract to Stark Excavating Incorporated in the amount of $330,973.02, and that's for the Underwood Park and Maxwell Park parking lots project, including the base bid, alternate 1, alternate 2, and a related budget adjustment of $16,827.02. A resolution to award the bid for the Bryan Street Water Main Replacement Project to George Gildner Incorporated at a total cost of $184,847, plus up to a potential $15,000 bonus for early completion. Please call the roll.
Mr. Fritzen?
Aye.
Mr. McBride?
Aye.
Mrs. Cummings?
Aye.
Mrs. Lorenz?
Aye.
Mr. Preston?
Aye.
Mr. McCarthy?
Aye.
Mayor Kus?
Aye, the omnibus agenda is approved. We have one item of general orders tonight. That is an ordinance conditionally approving the final plat of the MP2 subdivision by expedited process. This is having to do with the property at 2012 West College Avenue.
Move approval.
Thank you.
Second.
Second.
And before we get into this issue, the property owner, Mr. Nord, Mr. Stan Nord, and his attorney, Mr. Ryan Powers, have asked to address the council. So, gentlemen, come forward.
On March 19th, 2018, almost a year ago, this council refused to believe or look into my claims that some fees were not being collected per the code, and you told me to hire an attorney. Shortly after hiring an attorney, Mr. Day admitted, yes, the town was in error. Tap-on fees are required before issuing tap-on permits. One would have thought it would be obvious to collect a tap-on fee before issuing the actual tap-on permit, but this is government, so logic does not always apply. Since staff defended their failure to collect the fees, not as an error, but following their internal processes and procedures, which they developed for instances like this, that means this has been repeated, and fees have not been collected elsewhere. Taxpayers deserve to know how much in fees have not been collected, and the property owners need to be informed the town plans and expects them to pay for these newfound historical errors. This means every property owner in Normal, lenders, potential property owners have no idea of the financial obligation the town is going to assess them. There is no way for a bank to determine the financial risk for unknown town mistakes. No title policy covers something like this. Really, how can someone search unknown town errors? In this instance, the town is going back over a decade and 4 owners before I owned the property. This policy is going to devastate property values. Who is going to purchase or loan money on property in Normal if they know the town can and will for whatever reason, search through the past few hundred years of history and find where the town could have collected more money. As ludicrous as this sounds, this is exactly what is going on with the property before you. Bloomington was just in the news last week for a similar error. They failed to collect a required fee for over a decade. They realized how bad it would be if they charged 10 years of a town-caused error upon whomever owns the property now. Could you imagine the uproar if a new owner was given the bill or a lien filed for fees that occurred well before they even entered the community? The Lash Dairy Barn in Bloomington was going to get redeveloped. Bloomington said the property had never been hooked into the sewer, and a tap-on fee was due. When the developer provided the plans showing the connection existed, Bloomington just said, "Oh, well then, I guess you don't have that fee, and we'll have to update our records." How can things on our side of Division Street be so different? This is a huge property rights issue. What you are telling every voter, taxpayer, property owner, and potential property owner is property purchased in Normal cannot be trusted. Your checkbook will always be at risk for government to search the property records for a fee that was either in error or is now interpreted differently and make you pay for it. You will kill any new business considering to come to Normal. No bank will give a loan with such open-ended risk. You will crush home sales and home purchases. Would you purchase property with no cap on unknown fees? This policy has already caused a national distributor and seller, the largest one in their industry, to leave Normal and take their jobs and tax revenues with them. Whether you approve or deny this plat tonight is not the issue. This plat is for no change, nothing new. It shows your fees are for nothing in return. They are just to make up for an error caused well before I entered the picture. Tonight is merely a formality to get to court, so you don't set the precedents to destroy the property values of others in Normal. You made your decision clear a year ago, and through the conversations I have had with many of you directly, to those whose seats are up for election, you said, "I have to fight this on behalf of all property owners in court on my own." You are the elected representatives and leaders of our community. You should not put your head in the sand and turn your back on the property rights of the very residents who elected you and those who you are supposed to represent. If I lose, you will set the precedent for the entire state that ghost charges are okay in Illinois. This will give businesses and families yet another reason to flee or not enter the state. Whatever your decision, it must be a policy decision, one to be applied to all people. Because if it is not a decision you expect to be applied fairly and equally under the law, if it is just a policy to be applied to one individual, then that is discrimination.
Council members, my name is Ryan Powers. I'm Stan's attorney. We request that you approve the plat today without any conditions. It has been recommended to you by council that you conditionally approve it and that a sewer tap-on fee is paid. We think that that requirement, and Stan touched on that a little bit, is completely burdensome on individual property rights, as he articulated. It's unduly burdensome on the marketability of real estate. And if you only conditionally grant this plat, some of the legal challenges that we would bring up would be the doctrine of laches, estoppel, and just interpretation of the ordinance itself is what we're looking at. So a judge would make that ruling. And we're really hanging our hat on some of the language, for instance, in your ordinances that say that these charges are to be made separate and apart, that the sewer tap-on fee is to be separate and apart from any other charge. Well, you're bootstrapping a sewer tap-on fee to the approval of a plat. You can't bootstrap that. Another very important language in your own ordinances is that a sewer tap-on fee is a condition precedent, I quote that, a condition precedent to hooking up to a sewer. So the town has basically done it backwards. You're not following your own ordinances. The judge is going to look at that. The judge is going to interpret the plain meaning, the plain language of the ordinances. And there is some deference that you get in a court of law, and I think that will be something that we're going to have to fight about. But I really want to impress upon you that this really is not worth the taxpayers' money to hire outside counsel, to go into this battle when it's a mistake that you made. It's a mistake that was made, and frankly, we don't know if is this an anomaly or is this widespread. You have the 2 news articles I printed out here with Bloomington, and Stan touched on those as well. That's your sister city, and they're making it right. They're doing it the right way. So you have a choice here today to do it the right way, admit a mistake, not cloud the title of some commercial real estate, and then set bad precedent going forward. So we'd ask that you approve it with no conditions so that we can, avoid lengthy litigation.
Questions for Mr. Nord or his attorney? The issue we're here to deal with tonight is the conditional approving of this final plat. Before staff weighs in on this, I'm just going to make a personal comment. Since personal comments were made, the notion that property will not be sold in Normal and banks will not loan money to properties in Normal, I find ridiculous because properties are bought and sold all the time. There are issues having to do with tap-on fees and fees. Those are negotiated. Those are dealt with. The notion that this is going to end property development in Normal, I find to be a wild accusation. So at this point, I would turn it over to staff.
Sure. I'll just make a couple of initial comments, and I'll turn it over to Brian Day. I believe what Mr. Nord is referencing when he refers to unknown fees, I think it's relative to the sanitary sewer tap-on fee that applies, and I don't know that it was unknown because staff had communicated that with Mr. Nord prior to him acquiring the property. So I will ask Mr. Day to kind of explain the situation.
Sure. First, let me walk through a couple procedures issues. One is the request that this be approved without conditions. We can't do that tonight. This is brought to you on an expedited petition rather than going through the general process. And under an expedited petition, you can't have any code waivers. And so this would be a request to waive the applicable fees. So if they want to go back through the Plan Commission process and then come back to council with a request for the waivers of the code, that's something that can be considered. But tonight, we can't consider any code waivers because this is an expedited process.
To answer your question, there was no disclosure of exactly what all these fees were. When this was brought forward, I was told this was process. This was your normal, everyday process. Process, not mistake.
Okay.
In terms of the potential legal challenge, I mean, the question, well, one before the council is just simply whether or not to conditionally approve this plat based on whether or not the fees are paid. That's the only general condition is the payment of the sewer tap-on fee. We've got 2 ordinances under our code that deal with the tap-on fee and its payment. The first is in 7.22-6 that says that, as Mr. Powers indicated, that the payment of the fee is a condition precedent to the allowance of any tap-on. We've also got section 16.3-5 that says that any tap-on fees have to be paid prior to any plat being filed. The question there is, obviously, we can't file the plat under the language of our ordinance until the tap-on fee is paid or waived. Looking at these 2, we've got, if we go back and say, well, the condition precedent means we had to have collected it at the time it was connected to the sewer, then that means that we had an improper authorization back when it was initially collected, because it's not a condition to the tap-on, it's condition to allowing the tap-on that the fee has to be paid. If there was a mistake when that was made, the fee wasn't paid, then the allowance to allow the tap-on would have been improper. And the tap-on itself would have been improper, and the property has been benefiting from a tapped-on sewer for the last decade without the fee being paid for that service, and the taxpayer's been paying for the service to that property. So it's proper then to go back and either collect the fee, or if the allowance for that tap-on was improper, to require the disconnection from our sewer. If you've tapped onto our sewer, we found out it's an improper allowance, then a disconnection would be proper. And that's something we've made clear to Mr. Nord and his attorneys over the course of this entire dispute, is the town always has the option of requiring disconnection if the fee hasn't been paid for. Now, that's a very hard way to go about it, because it would be having to disconnect and then immediately having to reconnect and pay the tap-on fee. The better approach that the town has taken is to follow the language in the subdivision code that says that it doesn't have to be paid until subdivision's recorded, or we don't collect it until subdivision's recorded. I don't know quite, I've got some information that certainly Mr. Nord was aware of this before he purchased the property. There are a number of emails we've got informing Mr. Nord of what the fees were prior to purchasing the property. So anything where this was a surprise, he walked into that property sale knowing that the town was imposing these fees on this property. In terms of the laches or estoppel, those are equitable remedies. I don't want to get into a huge legal argument here. That's not quite the purpose of why we're here. Typically, they don't apply to local governments except in very specific circumstances, and this would not be one of those. Ultimately, for the past year, we've pretty much been asking, explain to us why this fee is improper, give us a valid legal argument, and we'll look at it, and we'll be more than happy to review any legal argument. We haven't gotten one yet. All we keep getting is threats of lawsuit. You know, the laches and estoppel is pretty much the first we've heard really of anything approaching a legal argument that we could respond to. That hasn't happened during the entire course of this. We feel the fee's valid, it's legally collectible, and until we hear a valid legal argument otherwise, staff's position is staff can't waive the fees. That's not in our purview. That's only something that council can do in the right process. So our choice has been to enforce the ordinances the way we interpret them.
Mr. Day, but the applicant submitted a request for final plat approval under expedited,
Correct.
an expedited final plat approval.
Correct.
So that's what we have presented to councils as it was submitted.
Correct.
Counsel, Mr. McCarthy?
So the vote then is if we're in expedited process, then either we're up or down tonight. We're not discussing anything else, basically.
Correct.
Okay.
There is always the option, if the property owner wants to take it back or to talk about potential fee waivers in the future. I mean, the council can send it back through the plan review process, through the plan commission,
So that would
and then
be,
have it come back to council, and then the waiver could be asked for then.
so is that incumbent upon us or the landowner?
It's primarily on the landowner.
That's, so withdrawing the petition and going back through the full process.
Right. Unless there's something wrong with the plat that needs to be discussed, you could send it back. But certainly if the landowner made a request to send it through the plan commission process, the council could at that point do it.
Okay.
So a clarification, Mr. Day. We have three options here: to vote yes on this, to vote no on this, or to allow the property owner to withdraw at this time and refile. Is that an understanding or
It
not?
won't take a refile. If, on the property owner's request, it could be submitted to the plan review or plan commission process without
So
separate application.
positive action would not interfere with his ability to do that if we were to vote yes on this?
I'm not sure I understand
How,
your question.
how would council vote on it? Just, would it be tabled? Would it be, if the property owner requested that it go through the planning commission process for consideration of fee waivers, how does council act
That would
tonight?
be, right now, an amendment. We've got a motion to approve the conditional plat. It'd be an amendment to that motion to send it to the plan commission for review through them.
Okay. Oh, should I?
Further on this item?
I would like to comment since you
Mr.
mentioned
Nord,
something for me.
we'll come back to you. There would
Okay.
be, we'll give you plenty of opportunity to speak. Mr. Fritzen?
You know, there is a lot of detail in this report that has not been discussed here, so I guess, I don't know if staff, other staff, you know, whatever, anyway, we've had a couple of different proposals in the past that have expired, and this is a new one that is brought to us, which I guess I'm a little puzzled as to why the application has been made when there's no site plan. You know, the report makes clear that typically there's a site plan for a parcel such as this that's within, you know, so many feet of a residential development, and so it seems to me that that's a bit unusual. So I'm wondering if that is the case, that it is unusual for a request such as this to be made when a site plan is required, and it's made without the site plan. I guess I'm having a little trouble getting my head around that initially.
Right, well, and Mr. Trumbull might want to respond to this, but I believe the site plan is going to come in the future if there's going to be any development on the property. So, but in terms of whether or not it's typical for them not to come together, I'll let Mr. Trumbull
I guess
respond
just
to that.
generically, it is a little unusual to have a final plat come forward without some, whether it's a plan unit development or a site plan or a subdivision to be developed, but not out of the realm of possibility. But as Ms. Reese indicated, that this is just one step in the process, and so then if Mr. Nord chose to further develop the property as it sits now, because of its proximity to the residential to the south, that would require going through a site plan process.
In addition to the tap-on fee, there are other development fees such as stormwater fee in lieu of on properties such as this, and you know, like I said, there's a lot in the narrative here, and we've had different plans come and expire, and another plan and attempt to put two parcels together, and now they're separated again. So there has been, as I read it, and I understand it in previous conversations with both staff and Mr. Nord, that staff has tried to work with Mr. Nord to identify parts of this property that are not developable and whatever, and kind of set them aside from some of the figures on the stormwater fee and like so. A larger set of fees could be imposed on this property, as I understand it, than what we have proposed, if I'm reading it right.
That's correct.
So, you know, like fees, like in the neighborhood of $45,000, we could make a case for that. But in trying to help work through the future development of the property or the like, the staff in their discretion have identified some, because of some streams through here and other things, that there is part of this property that can't be developed, and so therefore wouldn't have any need to be figured into that stormwater. So roughly 2/3 of that $45,000 has been set aside. So I think to me, that's an important consideration when trying to determine whether or not we proceed to impose the tap-on fee as it has been determined. I think that's, as far as questions for staff, I do have, some comments in response to some of Mr. Nord's remarks. To me, if an error was made 10 years ago, and in doing due diligence on this, whether it would have been with one of the previous owners of this property or the current owner of this property, that error is discovered, and a property has had the advantage of being tapped into the sewer for that decade, I appreciate the fact that the staff comes forward and says, hey, there was a mistake made, and the town wasn't reimbursed for, that tap-on. And they could have tried to sweep it under the rug, but I don't think that's how our staff operates, that they found that. So the insinuation is that this isn't a random occurrence, that this is this could be just widespread throughout the community and undermine the trust that the banking industry or developers might have in properties in town, and that simply isn't the case. I've been here for over the last 4 decades, and I don't recall ever having a situation like this come to pass. And when you look at the location of the property and the fact that for years we weren't going to jump the interstate when it came to sewer or water or whatever, and eventually the town made that decision to extend that way so that properties such as where Rivian Automotive is at some point in the future could be developed. I could see where an error such as this could have, in a random case happen. So I don't think this is something that anyone, as the mayor said, should feel is something widespread in the town of Normal. I don't think a professional staff makes this type of error over and over again. To me, this is an anomaly. I always find it interesting when precedent-setting arguments are made. To me, that's typically just a straw man argument. That every situation like this that comes before us, before the town, before the staff, there are peculiarities, things that can be assigned only to specific developments. And so in negotiations on development with developers, certain things are offered, certain things are discussed that maybe can help or help the developer, help the town. Both can benefit from it. These are just things that are typically done in situations like this without setting any kind of precedent. It may be a precedent specific to the piece of property or that singular development that is being discussed. That's true, perhaps, but each situation typically has to stand on its own merits. We aren't setting precedent with anything like this. I would ask that when a question of Mr. Nordson, when he's able to speak again here, when the council's finished, I presume that you have the authority to represent the former tenant. And here, because you stated specifically that they left Normal for another location because of this issue. Now, I've never heard from that tenant, and I don't know that staff has because there's never been anything in a report from that tenant. So I assume you have the authority to speak on their behalf this evening, because my understanding is they left Normal and moved to Bloomington. Maybe they moved because of the location. Maybe they moved for another reason. I don't know. But they've never been represented in any of the discussions or the reports that I've read on this. So if you could clarify that for me when you're able to do that, I'd appreciate it.
Mr. Nord, you're next in line here. Go ahead and make your comments.
In regards to the city not knowing about this and this being an illegal tap or insinuating that it could be. The city was involved in the design with this for well over a year. I mean, your engineers have got correspondence going back and forth. What the engineer and I were told was that this sewer line going through this property was built so that way it could be a public improvement at some point. So the town was fully aware that this connection was happening and was being built. The sewer fees, this property hasn't been connected to the sewer, not paying fees. Somehow, the sanitary sewer bill appears on the monthly water bill for I don't know how long, but at least since I've owned the property. The property taxes, it's been assessed as it's hooked into the sanitary sewer. So somehow, it got hooked in to the sanitary sewer. These other departments found out about it, and nobody collected the fee. So the town did know that this was being that it was being hooked into. And as far as notice, I would like to see the emails that state these are the fees and exactly what it is you're saying, because what was presented to me was not that. The town's staff, in their emails, when you look in these emails, they will say that this is the process. The reason that we have to go through this is because this is the process. The process is to allow to connect to the sanitary sewer and not charge until later. That is what the process was presented to me. And the reason that there's, I guess, usually a site plan is because the development happens after. The development has already been done. This property has been in the town for well over 60 years. It was developed once as a mobile home park, and then it was completely redeveloped again. So this has been under the town's purview since, I want to say it was the 60s when it was brought into the town. So this isn't new property. Rightfully, it probably should have been final platted long ago before at least the second development was done, but it just wasn't. And yes, if there is going to be additional development, then I'm sure there are going to be additional fees. But the crux of the matter is there is no development going on there. This is simply to clean up an issue that has been on this property for years. According to the town's code, it needs to be final platted, but it hasn't been. Permits have been issued for decades without final plat. Now that it's become an issue and it's been brought up to the attention that, where it is now, I can't even get a permit to put one bucket of gravel on this property without paying all these fees. So there is nothing I'm doing to this property, zero. After this is cleaned up, if I sell it or if somebody else wants to do development or if I do, then it follows the normal channels. But it's got to get cleaned up before anything can happen. I mean, I can't even sell it because it is so wrapped up in all these things that have happened on the property that should not have happened on the property. It's been out of order for decades.
Mr. Day, did you have a comment?
Let me go through a couple of issues. One, the issue isn't whether or not the town knew that the sewer had been tapped on, it's whether the fee had been paid or not. This is a very rare occurrence, almost 99.9999% of the time. A plat is filed before development and the tap-on fee is charged before the actual tap-on occurs because it's filed, or it's paid when the plat is filed. This is an extremely rare incidence where, for whatever reason, something happened before my lifetime in the property, a building was put on the property, and a plat didn't get filed. That's pretty much what led to the confusion about the fee when the permit was issued to connect to the sewer. I mean, our argument is that connection was improper when it happened because the fee wasn't paid. The property has been receiving this service, the ability to have been connected to the sewer since 2008 without having paid the fee. That doesn't mean the fee just automatically disappears and the taxpayers are expected to pay it instead. There's no legal precedent for that anywhere that I've been able to find. The fact that they didn't collect the fee before doesn't mean that the fee just goes away. In terms of can't sell because of all of the various issues, I don't know what else he's trying to clean up. The only condition we've got is the tap-on fee. That is the condition. That's the only thing that's at issue with this plat, and that's $11,904, I believe, is the total amount of the fee that we're talking about. In terms of what Mr. Nord knew before purchasing the property, I mean, I can go through the emails. There's an email from May 23rd of 2017 where Mr. Nord emailed the town planner asking, specifically stating, the property is currently hooked into the sewer, asking whether the tap-on fees had been paid, and it seems odd that they hadn't. She responded the following day on May 23rd, saying that the tap-on fee was still due, giving him the amount of the tap-on fee. We've got another email from June of 17 before he purchased the property. The west lot he doesn't own. Regardless of how I feel of the tap-on fees for the existing service, I've exhausted my efforts to try to understand those. I've come to terms that I just need to pay them. I hope you did not interpret me asking my attorney to verify this for me as something negative. I just need to get some advice. It goes on in that vein. And again, that was prior to him purchasing the property. Now, knowing about these fees before he purchased the property has two effects in this matter. First, certainly it's going to affect any legal case in that you can't just knowingly walk into a situation and then claim that the situation's unfair when you knew about it ahead of time. The second issue is this advance notice gave Mr. Nord the opportunity to settle with the seller of this property. He's buying the property. There's an $11,000 fee on the property. He can argue for a credit against the purchase price of that property. Either he did, he got the credit, and now is looking for a windfall from the town, or he didn't, and he didn't take advantage of the opportunities available to him, which means that he can't plead an equitable cause of action now when he didn't take the steps to protect himself when he purchased the property.
Thank you.
Mr. Day, if I could also add, just for clarification, just to clarify, I suppose, the difference between the tap-on fee and then the monthly consumption fee or user charges. The utility bill contains the sewer fees associated with consumption of water, which therefore goes down the sewer system and such. So there is a monthly utility bill. Certainly, those have been paid. What we're talking about is the sewer tap-on charges, which there's a tap-on fee because, and we explained it in a report, but not everybody has access to this report or has looked at it, but when the municipality extends the sewer system, when we install sewer mains, we generally front the cost of that capital investment, and then we assess a fee per acre in order to ultimately reimburse the municipality and the citizens for the fronting of that capital investment. And so what we're talking right now is the original capital investment that the municipality made to extend the sanitary sewer. And when the entire investment was done, there was a $744 charge per acre in that sewer service area. Is that an accurate statement, Mr. Day?
Yes.
Yes. And so that's the fee that we are talking about, is the reimbursement to the municipality that's applied to the whole area that's covered by the sewer system, and is a per acre charge.
Mr. McCarthy? And then Mr. McBride.
One of the more technical things we've considered in a while. I suppose just a little clarification, then I also have a question for Mr. Nordwin, and his time is if he chooses to speak again. So the statement was made burdensome, and I'm struggling because as the facts have been presented to us, is that we've reduced fees by almost 70% of what could be due on these properties. Is that whether staff or Mr. Day or?
That was for the prior, so there was a prior plat where Mr. Ward wanted to combine two parcels, and yes. In
Which
that
brought this whole
case,
issue.
we had dropped, the fees
Yep.
were originally close to 45,000. We'd worked through various means to find ways to reduce them to about 14,000.
Okay.
But
So-
that's, yeah, an issue, though, most of those fees, though, aren't going to apply in this
Mhm.
case. This plat is just the tap-on fee.
So I raised this issue because it seemed like staff was in good faith attempting to help out Mr. Nord in the situation because of the circumstances of the case and some of the features of the land that don't appear to be developable. And so it seemed like the town was, or at least staff was working to be very accommodating to try to make it not burdensome for the property that was owned and what he intended to do. So I struggle with a burdensome perspective. Mr. Nord, when you have the opportunity, if you choose to speak again. In your opening statement, you said that you're making no changes and that this is just a plat, and then this is just a formality to get it into court. I'm asking Mr. Nord. Mr. Nord, is that what you said? And is that your intent, to go through this process just to go to court?
My intent was to bring to light that this was a charge that happened a decade before I owned the property. And when I brought this before you, you told me to hire an attorney and take it to court. So,
Me? I told you that?
well, if we look at the video from March 19th, a lot of folks did, and that was what was told,
I don't recall.
was that if I need to take it further, I need to hire an attorney and go through the legal channels.
So to be clear, to challenge this in court, there's a requirement that you exhaust all administrative remedies first.
No,
So that's exactly what he's referring to, that in order to get into court, so we don't just get thrown right out of court, we got to come to you again and say, shoot us down or grant it. And then we'll go off of that, so.
I appreciate that,
Yeah.
thank you. But my question is the intent here to plat without a development plan, just to do, or is this a formality from your perspective, just to go to court?
No, I mean, that would actually clear up everything if it were final platted, because this should have been platted before it was developed, but unfortunately, it's been developed before the final plat.
Okay.
I mean, there's structures that are on there, if you guys have seen pictures, it's been there for a long time.
So, some statements were made by Mr. Nord and his subsequent comments that fees have not been paid all over the place. I don't know that we have any proof of that or evidence that this is a widespread practice, that things are due. I imagine that there's quite a bit of property developed west of Mr. Nord's property, some residential that has been developed since I've been on this council, and these issues have never been raised. So that seems to be a somewhat inflammatory statement, that we have no proof of that, but just is being attempted to be entered in the record for dramatization. Last thing, I guess this is a Mr. Day or staff question, really. And I think I heard the answer, but I just want to double check. So if we approve this, does this in any way inhibit Mr. Nord's ability to go back through the full process?
I'm not sure I understand your
So if
question.
we vote yes,
If you vote yes on this, then
conditionally,
Right. And then Mr. Nord has the opportunity or the decision to make whether to pay the fee, file the plat, or to take legal action.
But he can't go back through the full unexpedited process.
Or, I mean, if the council tonight or wants to send it back through the plan commission process, again, with Mr. Nord's approval, then he can come back and ask for a waiver of the fees at a later date after it goes through the plan commission,
Which would require an amendment.
which require amendment of the existing vote. So it wouldn't be voting yes on this expedited plat. It would be to refer the matter to the plan review or planning commission, and then it would come back on a non-expedited basis. And at that time, Mr. Nord could request a fee waiver.
Mr. Day, though, if I'm understanding Mr. McCarthy's question, if council approved the final plat as proposed tonight, if the
Conditional.
yes, as proposed, could the property owner in the future decide to go back and ask for an amended final plat before it's recorded and ask for fee waiver through that process?
Before it's recorded, if he wants to file another application for non-expedited, yes, that could happen as well.
Thank you.
Mr. Mr. McBride?
So, question first of all for Mr. Day. So we've kind of exhausted that possibility. I feel at this point we almost need a decision tree, or it's one of those make your own story, turn to page 72 if you select yes, and if you select no, turn to page 43. If this council were to vote down what is in front of us tonight, what are the property owner's options at that point?
Basically, we don't really have a good reason to vote down. I would advise against voting it down simply because the plat meets all of our requirements, so we don't really have a good faith reason to not vote to approve the plat conditionally. So I would advise against that just because we don't really have a valid legal reason. The plat meets all of our technical requirements.
That's kind of what I was driving at, so thank you. And then, again, this can be answered by Mr. Nord or his counsel if I suppose they so choose, and it's maybe reinforcing or asking Mr. McCarthy's question in a little different way. But if I may ask, what is the ultimate objective here tonight? Would it be seeking approval without any conditions, which again, from what I understand, would require going back through the process? Or is it in fact, because I heard the same thing that my colleague did about it being a formality leading to litigation, is the idea, frankly, just to set up some sort of trap for us that would bolster your chances for successful litigation?
Well, we would, want to have no tap on fees, and so it would be unconditionally approved with no conditions. And correct me if I'm wrong, but that would resolve the issues. So if you think it's worth our time to amend it, come back, put it through the full process, and see if we can have you vote on a waiver of those fees, that would be a good outcome. And I'm speaking on Mr. Nord's behalf, but would you agree with that as well?
I would agree with it. Even if they approve this without fees.
But that wouldn't
No, that doesn't.
prohibit you from planning.
It doesn't.
So again, if this was a plat with no conditions, that would be a desirable outcome.
Okay. So there is some willingness to go back through the process and realizing, of course,
Yeah.
there's time involved.
Sure, I mean, and we wouldn't be very happy if we had to go back through the process, and it would just take longer for us to eventually hash this out, whether that be in litigation or not. But it sounds like I'm kind of getting a good vibe that maybe maybe it would be a favorable vote to have those waived. Either way, it would be still, I think, a requirement of exhausting our administrative remedies first. So I think we might have to do that legally speaking, so that it doesn't get thrown out on a motion to dismiss in a court.
Okay. I'm just trying to establish what the
Yeah.
objective is. Thank you.
Thank you. Ms. Lorenz?
Yeah, listening to the comments from the property owner and his legal representation, I'm just struck by how odd this seems. The timing of it seems rather odd. In essence, you've had two parcels or two segments of your property. And the first segment a year ago was discovered, as outlined by these emails, to have some uncollected tap-on fees. And so there's been some back and forth, and if I understand correctly, about 65 or 70% of those fees have been reduced in an attempt to lower the burden that was discovered by these unpaid fees. So, a 2/3 discount. It sounds like there was trying to be some negotiation through that administrative process. And so that's over here as segment one. And tonight you come with segment two of your property, where you're saying, okay, I'm not going to talk about this, I just want to talk about this segment over here. And this segment over here, I don't plan to do anything with it, but I would like to be able to plat it, and with that comes the condition that should I do anything to it, I owe the fees. And you came to this today in an expedited fashion, assuming you knew that you didn't have the option of getting out of that condition. But you come tonight anyway, asking for it. So what seems really weird to me is much of the discussion and prepared comments has been all about this stuff over here. And I find that really weird, that you're discussing, yes, it's still part of the property owner's parcel of land, but it's really not germane to what today's agenda item is. Today's agenda item is all about segment two, as I understand it. And you've come here in an expedited fashion, and unfortunately, your request here to undo the condition is not possible. So for that reason, when the time is appropriate, I would support a motion to send this back to the Planning Commission. Do I have all of those facts clear, that we've got kind of part one, part two? Am I understanding that to be correct?
Mr. Day?
Just by way of history, so back in 2017, there was the MP1 subdivision. There's two lots that are right next to each other, next to I-55. There was the MP1 subdivision that Mr. Nord platted without a site plan. That got platted, I think, 2017. He then purchased the property next door to that. And he filed a plat to combine the two, and that came with a site plan that would allow him to develop both parcels.
Okay.
And that
That's number
was
one
the
over
first
here.
addition to the
Right.
MP1 subdivision, and that was the one where the fees were,
That
well, the
question.
fees are mostly imposed to that second. Fees were paid on everything on the first parcel, the MP1, back in 2017. So we're talking about, when he tried to combine the two, there were additional fees that were applied against that second parcel that he tried to combine.
So now he's saying,
So
I
now.
don't want to do that anymore.
That expired.
Yeah.
That, the MP1, this council back in March, or the first edition of the MP1, the council last year approved that conditionally with the payment of, there were two fees at issue there. One was the same
Tap-on.
tap-on, and there was a stormwater facility.
Right. And that's where we gave the 60-some%
Right,
discount.
yes. And most of the discounts that were involved in pretty much the combination of those two parcels. And that was the one that had the outlots that we weren't charging the fee, the per acreage fee against. That expired back in June. Plat approvals expire after 90 days if the conditions aren't met automatically. It expired after talking to his lawyer early last summer. We had agreed to extend it for an additional 90 days to try to work this issue out. When there was no traction on that, that expired again in September of 18. So then there's been nothing on the property. There's no active plats on that property. With respect to trying to fix these problems, if there isn't any development, I mean, the town's not saying you have to pay the fee now. We're just saying a plat can't be recorded until a fee is filed. No one's going in right now and saying you have to plat this. In fact, we've sat there we haven't told them at all it has to be platted unless there's some kind of development on the property. So if there is no development on the property, the town's not requiring the submission of any plat.
Right.
It can sit there. All we're saying is any development's going to require a plat, and any plat can't be filed until the outstanding tap-on fee is paid under our ordinance. But if there's no development on the property, he doesn't want to file a plat, it can sit there until
Wants to do something.
somebody eventually wants to do something on the property.
Well, thank you for clarifying and confirming that. I guess I'll just come back around to saying that the timing of this seems weird, and the amount of time that we've been discussing the other matter seems strange, and I'd like to turn our focus back to the MP2 that's in front of us today, and it would seem to me that the best course of action would be to not have come here on an expedited, but instead go back through the Planning Commission process.
Further discussion on this item. So my understanding is we've been advised not to vote no on this because it is substantially meets all the requirements for a expedited final plat. We can vote yes on this, and the applicant has how many days before the plat is certified that he would have to request that this go
The
back?
conditions would have to be met within 90 days.
90 days. And we can amend this to ask to send this back to the Planning Commission, go through the full process. Is that correct?
Correct.
Okay. And I think it would be appropriate to give the property owner and his attorney an option to state their preference, so what they would like to do going forward.
Yeah, we would support amending it and letting it go through the whole process for the staff to consider maybe a waiver because of the unique situation of the property. That would help alleviate, I think, any future litigation if that was allowed to happen.
Is there a motion to amend?
I'll make that motion.
Second. Is there discussion on the amendment? Please call the roll.
Mr. McBride?
Aye.
Mrs. Cummings?
No.
Mrs. Lorenz?
Aye.
Mr. Preston?
Aye.
Mr. McCarthy?
Aye.
Mr. Fritzen?
No.
Mayor Kus?
Aye. The amendment is approved. We need a vote on the full on the full.
Correct.
Is there further discussion on that? Please call the roll.
Mrs. Cummings?
Wait a minute.
Yeah, I don't understand this either.
So we have to also vote on the original one since the amended
the
one?
It's amended.
Okay.
I'm sorry.
It's,
Original as
we amended it, now we have to vote on
Okay.
the amended
On the whole
ordinance.
thing.
No.
Mrs. Lorenz?
Aye.
Mr. Preston?
Aye.
Mr. McCarthy?
Aye.
Mr. Fritzen?
Aye.
Mr. McBride?
Aye.
Mayor Kus?
Aye. The amended ordinance is approved. We have no new business tonight. Before taking a motion for adjournment, are there concerns or comments? I would just make one, if people are listening, tomorrow is Election Day. Regardless of your candidate that you support or don't support, please go vote. It's your civic duty to do so, and please do so. Motion for adjournment.
We adjourn.
Thank you. Please call the roll.
Mrs. Lorenz?
Aye.
Mr. Preston?
Aye.
Mr. McCarthy?
Aye.
Mr. Fritzen?
Aye.
Mr. McBride?
Aye.
Mrs. Cummings?
Aye.
Mayor Kus?
Aye. We are adjourned. Thank you.